Well, good evening, everyone. My name is Eric Lee. I am the Neighborhood Development Officer for the Northeast region of Baltimore City at Department of Housing and Community Development. We welcome you tonight to the Baltimore Builds webinar series titled Receivership 101. And we thank you for joining us tonight. You did hear that this session will be recorded. And joining me tonight are my colleague Kelly Bakula, who will be answering questions that we asked you to put the questions in the chat, and she'll be answering the questions and facilitating the question and answer period at the end of the presentation. We also have our colleague Howard Tutman III, who's with us tonight, and leading us at Department of Housing and Community Development in Marketing and Outreach is Teresa Stevens. She is Director of Marketing and Outreach. Tonight's webinar series, as I said, is called Receivership 101. And our two presenters tonight, Kathleen Byrne, goes by Katie. She's the Assistant Deputy Commissioner of Litigation, from what I understand, all things code enforcement. And we also have Pia Helslip, who is Executive Director of One House at a Time, also known as OHAT. And so we're ready to begin, and we will turn over the presentation to our presenters tonight. And again, please put your questions in the chat. We will answer them at the end of the presentation. Thank you.
Thank you, Eric. Pia and I will hopefully give you all some really good information about what receivership is, what receivership isn't, what it does, and what it doesn't do when it comes to vacant buildings in Baltimore City. So I'll be walking us through the PowerPoint. I'll be kicking it off, and then I'll be turning it over to Pia when it comes time for OHAT, but I'll continue to monitor and run the slides. So welcome. All right, let's see if I can get it going here. Now, of course, it worked great for me when we were practicing. I seem to advance the slide. Let's see. There we go. All right, now it looks like I know what I'm doing. So I think I muted myself by accident. There we go. Boy, it's just running off to the races here virtually. All right, so we have a vacant building problem here in Baltimore. Back in 1950, we had a population of close to 1 million. Today, we have a population close to 600,000. And as a former boss of mine said, when they left the city, they didn't take their houses with them, right? So we have approximately 16,000 vacant buildings in Baltimore City. About 10,000 of those are in concentrated areas. About 6,000 of those are scattered sites. About 2,500 are actually city owned. There are a variety of strategies related to how we combat vacant buildings. Demolition being one of them, kind of an obvious choice, but a very expensive choice because we are a city of attached homes, of row homes. So if you're going to take one down, you have to deal with all of them. And taking one down is as expensive sometimes as taking down the whole row. We have traditional code enforcement tools like injunctions that our code enforcement lawyers file on a regular basis in district court. Citations for owners, we continue to cite them, tell them that they need to renovate their properties, assess liens against them, and there are also criminal penalties. But again, criminal penalty, all that does is punish the owner. It doesn't do anything about getting that vacant building rehabilitated. Citations, more liens, injunctions, again, kind of the same thing. So we have another tool that we use, and that's our receivership tool. So really what to do? It's a problem of varying proportions, right? We have properties that are owned by deceased owners. We have properties that are upside down for mortgages. We have properties that, potentially were fire ravaged and the owner didn't have insurance. So then they are left. And in 1992, the vacant building statute was passed, and the vacant building receiver, and it comes into section 121.1, and it applies to properties that are defined as a vacant structure. It's a nuisance abatement tool. So what it allows the building official to do is file a receivership action in district court, and it has to identify that there is a vacant building notice on this particular property, that notice remains unabated, and that this property is a blight upon the city, right? That is a nuisance. The nuisance is the most important factor in filing a vacant building receivership. So how do we define a vacant building? The statute says essentially properties defined as vacant are deemed nuisances per se. So remember I said receivership is this nuisance abatement tool. We file it to get rid of this blighted property, and it has to be a vacant. What are things that are vacant? Things that are vacant are open to casual entry. Maybe it doesn't have windows, doesn't have a roof, missing part of the side, doesn't have essential services, heat, hot water. It's essentially uninhabitable for someone to live in its current condition. And a notice has to be issued by the city in order to designate it as a vacant building. So that unoccupied property next to you, maybe that's awaiting foreclosure, that doesn't mean it's a vacant, right? It needs a vacant building notice issued by the city in order for a receivership action to be filed. So we look at different strategies to tackle vacants, and we have, like I said, a variety of tools, and we use, and I'm hoping that most of you on the Zoom today have used codemap. It's a fantastic tool. It's something that everyone on our staff uses every single day in order for us to get a true feel for what's going on in a variety of neighborhoods. We identify properties that are vacant. There's different ways that we assess and tackle vacants, and receivership is one of them. So it is a litigation court process. So the city files the receivership action against the property and all others with a secured interest, and they're served with the complaint. So if we think about people with a secured interest, it's the legal property owner, it could be a mortgage holder, it could be a lien holder, it could be like a third-party lender, whether it's a bank, whether it's a private lender. And we look for all judgment creditors, and all of these people have to be notified. So anybody that has an interest in the vacant, even if it's really not worth anything, they still have to be identified and served. And then a receiver gets appointed, and the receiver under the statute, they can sell it, demolish it, or rehabilitate it. The court, however, may allow an owner, a mortgagee, or another person with an interest to rehabilitate the property, but they have to show that they have the ability to do it, the experience and means to do it, and they have to identify essentially that timeline. If not, if the owner or another lien holder doesn't have the ability to renovate the property and they haven't proved that sufficiently to the court, then the court will appoint the receiver to sell the property to abate the nuisance, right? So at the end of the day, what the court is telling the receiver to do is you need to sell this to a person who can actually get rid of that vacant building notice. So the receiver is appointed by the court. The receiver does not work for the city. Now we work closely together, but the receiver answers to the court. Receivership can transfer or rehabilitate the vacant building. So to transfer it, it has to be sold at a public auction to pre-qualified buyers. The only time that there is a private sale, all parties have to agree to the price and how that's established. So I can tell you in the more than 20 plus years that the statute has been on the books, I can think of only one time that this has actually happened, because all parties have to agree. That means the owner has to agree, the lender has to agree, the court has to agree, the city has to agree, and the buyer has to agree on that agreed upon purchase price. So like I said, that rarely, if ever, happens. So the most part, properties go to the receiver, they are sold at public auction. Now the statute says that they have to be sold to the highest bidder. Now, the reason is if we all think about our Constitution and our constitutional law, it is designed to protect property owners. So to avoid any kind of taking action, it is something where that property owner, no matter how poorly that property owner behaved in the past, they are still protected because this is their asset and it is being sold because they have failed to abate a nuisance. All right. So property owners can avoid appointment of the vacant building receiver, as I stated a little bit earlier, by presenting to the court the ability to raise or rehabilitate with a reasonable time. Now remember, it's a nuisance because of a vacant building notice. And there's two ways to abate a vacant building notice. You can demolish the property, right? That gets rid of the vacant building. Now you have a vacant lot. And under the statute, a vacant lot is not a nuisance. It's the structure itself that presents the nuisance. So if the owner decides they want to demolish the property, then we end up dismissing the case. The nuisance is gone. They can show that they have the ability to rehabilitate the property within a reasonable period of time. Now, the court historically has been very lenient in allowing property owners the ability to see if they can come up with the money, find a contractor, come up with the timeline. The court will give them the time that they need if they even show the slightest bit of ability to try to renovate the property themselves. We generally will enter negotiations with the owner to try to come up with a specific schedule for raising or rehabilitating the property. Sometimes the court will ask the owner to post a bond as some kind of security for performance of the work in order to get it complied with in a set period of time. I will tell you, over probably the last 5 years, mortgage holders have a number. So if the property owner can't necessarily renovate the property themselves, if there's a lien on the property, sometimes the bank will go in, they'll make an assessment, make a determination as to whether or not they want to put X number of funds in it so that it avoids going to a private auction, then they would foreclose on that note. But if the numbers don't work out for the bank, then the bank will a lot of times consent to the vacant building receiver being appointed. So receivership is specifically not a government taking. And this is important to understand, that it is considered the city's police power to abate a public nuisance. That's why that vacant building notice is so important and that public nuisance is so important. The city cannot and does not take title in this particular way, and it cannot direct who the property is sold to. Only the receiver must follow the rules set forth by the code and under the Maryland rules for judicial sale. So it is essentially the abatement of a public nuisance. The outcome is a use and occupancy. It doesn't matter who gets that use and occupancy. It is the abatement of that public nuisance that is the heart of a receivership action. But what we find is that as a code enforcement tool and working with community and looking at different areas where we file receiverships, ultimately it strengthens community. Properties that are vacant, obviously they attract trash and graffiti. They bring neighborhoods down. But receivership can quickly move, and I use the term quickly in the legal sense, which is not super fast, but faster than other methods, to a qualified third-party person who can rehabilitate the property. Here's an example of a before and after. So we decide where to file properties a lot of times based on the market. So there are sometimes properties, you'll look at a neighborhood, there's one vacant building on an entire block, or maybe two, and you're like, what's going on here? Should be a stable block. There's no reason why these properties should be vacant. So we look at those and it's usually stuck, right? It's deceased. There's a mortgage foreclosure the bank hasn't necessarily moved on. Again, someone is just not paying attention here, and we can go ahead and file on those because we know that there will be a buyer at the end, and ultimately that vacant building notice will get abated. A lot of times in the better neighborhoods, the bank wakes up and they're like, oh, wait, I'm going to go ahead. I'm going to step in. Estate sometimes is open for the deceased property owner. The family members try to come forward. But then there are times when you see pictures like this on this first one, where we have a lot of vacants in a block. And there was a time, and I think there still is a time for certain neighborhoods in the city that, but for having someone essentially be a bidder of last resort, saying that, if these properties you would receiver them, we would buy them, we wouldn't necessarily file receivership actions. Like, we wouldn't file receivership actions only on the one on the end. We would file it on the entire block, because you need the outcome for the entire block. So we look at things individually, we look at things on a block face, and we look at market forces. By transferring to third-party developers, we can save the city a lot of money as far as acquisition and rehabilitation dollars. So like this one, for instance, the individual buyer bought it at receivership auction and then immediately demolished it. Cleared the land, bought some other properties around to do new construction and renovation. Again, the abatement of the notice happened when the vacant building was demolished. And this saves the city the time of trying to go forward and do this. And this could be years and years in the making before we would ever have the time or the money to demolish a property. Targeting the individual properties, as like I just discussed, we have these kind of crazy one-offs in really stable neighborhoods, but for something weird happening with title or banks or deceased property owners, us having the ability to file that receivership on this one really can move properties that are essentially stuck. This one, again, another example of a cluster where we filed on all of them. They were 5 adjacent fire damaged properties. We needed all of them to move in order for it to turn around. Again, codemap. This is an old screenshot of codemap. If you have not been on codemap recently, so much good stuff on there. I would encourage all of you to get onto codemap, essentially desk drive around the city, find out where the vacants are, see if it's close to where you're doing work, and definitely use codemap as your source for looking at what's happening in the city. Time frame for receivership. So generally, when we identify a property or a referral comes to us with a vacant building notice, the attorney whose district it is assigned. We'll take a look at it. We'll file for title work. Generally, that takes anywhere from 45 to 60 days. And about 120 days for us to get that vacant building receivership. I'm going to have a little bit of a disclaimer. This is what normal times look like. Just so you know, we are about a year behind in filing receivership actions because we went more than a year without the ability to file new cases. So we are quickly trying to get back up to speed as fast as possible with the court, but we were unable to file new cases until very recently. And the cases that we did have in court back in March of 2020, we essentially had to start over with all of those. So this timeline would be under normal circumstances. I hope that it doesn't take us a full year to catch up. I am a little fearful that it will, but under normal circumstances, approximately 120 days after referral, we can get our first court hearing, we can get the petition served. And because all properties are unique, because all ownership is unique, we have this kind of average from 120 days to 160 days, right? Till we get to that auction. So that assumes that we're able to get the vacant building appointment quickly. So those ones that I showed you earlier, where we had those 5 brownstones in a row, where if we're trying to get all of them to auction close to around the same time, one could just hold up the whole group. Like we could get maybe 4 that are appointed fairly quickly, and then one where we have really difficulty getting that appointment, whether we're having a hard time serving the property owner or the lender is taking their time saying, well, maybe I want to renovate the property, right? So once we get into court, it's anybody's game. But all things considered, if we can get to auction 160 days after referral, then there's approximately an additional 60 days to get the sale ratified. After ratification of sale, hopefully by day 240, transfer to a new owner. So all things considered, this is faster than tax sale foreclosure. This is faster than mortgage foreclosure, but at the same time, it is a court process and each one is unique and will take its own time as it proceeds through the court. On average, on good years, not on a COVID year, we are averaging around 500 cases per year. Since 2012, we've had more than 5,000 receiverships cases filed. In 2019, over 5 million in total sale proceeds. Since 2011, over 2,500 use and occupancy permits issued from a case being filed. So it is a great nuisance abatement tool. Now I'll turn it over to Pia.
Great. Thanks, Katie. Good evening, everybody, and thank you for being here. My name is Pia Heslip, and I am the Executive Director of One House at a Time. We are a nonprofit organization whose mission is to transform vacant properties through receivership and thereby improving Baltimore neighborhoods. As a court-appointed receiver, we facilitate the transfer of Baltimore City vacants to qualified rehabbers. And just to reiterate what Katie said, it is the district court that appoints us as the receiver and not the city. Next slide. Katie, can you switch to slide? Uh-oh. There you go. Okay, so what does the court order say? As a receiver, we must transfer the property to an entity that will abate that nuisance through renovation or demolition. And we do this through public auction, as Katie mentioned, and we offer the auction to pre-qualified bidders. Public auction means that we follow rules regarding notices and advertising, and according to the statute, we have to sell to the highest bidder. To become a pre-qualified bidder with us, you must be able to demonstrate the ability and the expertise to rehab the property within the year. And I'll expand on those requirements in a little bit. Next slide. Here's a short summary of what we do. We pre-qualify bidders, we conduct auctions, we submit the court filings, we work to clear title and coordinate settlements. We prepare and file what's called a final accounting to the district court. And once the court ratifies that or approves the final accounting, we distribute the proceeds. And once the transfer is complete, we will ask the court to terminate the receivership. And somewhere in there, if it happens, we will also respond to any legal action that will come up at any time during the receivership process. If there's motions to, file a lien holder files an exception to the sale or anything like that, then we'll respond to those actions. Next slide. What is expected of receivership buyer? Other than you have to abate that VBN and obtain a UNO within a year. Some of the main things we would like for our buyers to do is to communicate with us. Because time is of the essence in these transactions, we would really appreciate it if you would respond timely to requests, to scheduling your settlements. Once we have the sale ratified, you must settle on the property within 30 days. So we try to facilitate that or expedite that as much as possible. Also, with any development, anything can happen. There's always, there could be a snag anywhere. So even though, we have that 1 year time frame to renovate, if something happens, there's, contractor issues or anything like that, please communicate with us. Let us know, let the city know, so that we're aware of what's happening. We're understanding of development issues like that, construction issues. So we're able to, give a grace period or provide an extension to that 1 year. Also, please read your contract of sale. We have copies of that. Our AJ Billig has that on their website. We can provide you a copy of that. So it's a one-page contract, but there's a lot of information in there of what is required of you. So please read that. Again, once you have the property, then you have to be able to get a UNO within 1 year. Next slide. Okay, taking properties to auction. So once the property has been placed in receivership and a 30-day appeal period has passed, the city will give us a list of properties that are ready to be auctioned, and we will begin the process of preparing that property. So we will set an auction date. We will post those properties on our website. We will place legal advertising, and here's an example of what you would see of what our legal ad looks like. We will secure the properties. So we put a lockbox on each property, and if they need to be boarded again or just secured, we will do that. If the properties are safe enough for entry, we will we'll place the combo locks there. If not, then we'll just make a note that it's not safe to enter, or we just won't make sure that everything is secure. We do highly recommend that you visit the properties before you bid on them. I don't know how people can bid on properties sight unseen, but we do try to show as much of the property's condition in photos, but it really does help if you visit the properties first. Next slide. How to qualify to bid. Our application is on our website. I do see some folks here are already qualified bidders and are familiar with that process. We renew your bidding rights annually, and the applications are due 5 days before an auction, the auction date that is advertised. For online auctions, there's going to be 2 dates. There's going to be an opening date and the closing date. So it'll be 5 days before the closing date is when applications are due. If you have any trouble with the application, just feel free to call us or email us. We would be happy to walk you through the application. We've made it as simple as possible and as easy as possible. You will need to provide extra documentation as well with your application. I also want to say too that, I guess we can go to the next slide, Katie. In order to qualify as a bidder, you need to show that you have the financial capacity to be a bidder. So that means you need to show that you have a minimum of $90,000 in liquid assets per property that you want to bid on. You also need to show that you have experience developing and rehabilitating similar properties. You've pulled permits before, you've gotten UNOs before. You also need to be of good standing as a property owner in Baltimore. We're also related to ownership of other vacant, your payment of property taxes. You can't have citations in your other properties. You can't have VBNs on other properties. In some instances, we can, if you're assembling a site, for instance, and a couple of those sites that are non-receivership have VBNs, then let us know. So we can, we'll consider that in your application. We also need to be in good standing with the state of Maryland. I also want to say too that receivership really isn't for first-time rehabbers. This is not where you would cut your teeth in real estate development. These properties are very poor condition, they're uninhabitable, and they require a lot of resources. And as what Katie said, it takes a long time to get it. Sometimes clearing title takes a long time. Getting liens removed takes a long time. So being able to, I guess, hold those properties for that time period is really, it's crucial. You need to be able to sustain that. Let's see, next slide. Okay, finding properties for the auction. About 4 to 5 weeks before an auction, we will send out a preview list of addresses to those on our mailing list. So I'd encourage you, if you're not on our mailing list already, to sign up. It's on our, you can go on our website, and there's a sign-in form on our site, on our homepage. You can find a list of properties both on our website and on our auctioneer's website, just AJ Billig & Co. AJ Billig will also send out emails to those on their list advertising the sale. Next slide. The auction process. So we try, I guess last year was a little bit tricky, but we do try to hold, we typically hold our auctions every 2 months. In between those months, every once in a while, if it necessitates it, we will have an on-site auction. These are in-person auctions on site, and it's usually for properties that are clustered together. Since 2020, we've moved all of our auctions online. I'm not sure when we'll be able to do indoors, an indoor gallery auction again, but hopefully we will do that. We'll start doing that again next year. But so far the online platform seems to be working fine. I know some people have some issues. There's some issues that have come up with having auctions online these days, but I can discuss that in a little bit. The bidder applications and deadlines and things like that remain unchanged, even though we're doing things online. But there are some extra steps in the registration in order for you to bid, to participate in the online auction. And that, let me see, what slide are we in? Okay, we'll see on this side. So anyway, here's some of the rules for the auction. Bidding starts at $5,000 and all the properties are sold as is. We require a minimum deposit of $3,000 or 10% of the sales price. You will leave with a contract of sale. Now, in pre-COVID times, in the gallery auctions, when we used to have it at a hotel, you signed the contract right at the very end of the auction. When it's an online, this time when we're doing online auctions, you have to show up to our auctioneer's office to sign the contract in person and provide your deposit. So if you are unable to do that on the day the auction closes, don't participate in the auction. Or if you're going to participate, let us know ahead of time if you have an authorized signer and who can sign the contract for you, who can appear at the auctioneer's office for you. Let's see. And one more thing to note too, on online auctions, you will not be allowed to register on the AJ Billig's website. You have to submit, you have to let us know, let One House know that you're interested or you want to register for the auction, and you have to supply us with a government issued ID in order to do that. From there, we will manually register you on the auction, and then you will receive information from AJ Billig on how to log in, password, and other instructions on how to use their bidding platform. Okay, next slide. Okay, auction day. Used to be like this photo, but it's not like that anymore. The publicized auction day is when the bid closes, as I mentioned. The bidding for properties will typically open. So we've been having our online auctions on Tuesdays, the closing on Tuesday, so it will typically open on a Friday. And one thing that is important to note on the bidding platform is that when every property will have a closing time of every 5 minutes. During the last 60 seconds before a bid closes, if another bid comes through in that window, there will be an automatic 60-second extension. So this is very important to note because I think some folks have been tripped up by that, thinking they can bid at the last second, but it actually will extend that time period another 60 seconds. So that's important to note. If you win, you will be contacted by email or phone call by a representative of AJ Billig to let you know what time to come into their office to sign the contract in person or your designee. Deposits and contracts will need to be executed by close of business day. If you fail to appear, you will be prohibited from participating in our auctions for 3 years. Now this is a new rule instituted last year because when we used to have gallery auctions in person, we've only really had one person who was a runner who left before signing a contract. Now that we have this online platform, things are a little bit different, and we've had more instances of people winning a bid and then not showing up to sign, which really creates a huge issue for everybody. So we've made the penalty for not showing up to the place of deposit or sign a contract, more serious than failing to settle. Again, really important. If you can't be there, don't bid. Or send us the name of the person who will sign on your behalf. Another thing to note too, and I think I've seen some comments on the chat about this, is that because of the market forces in the past year or so in real estate and the fact that we're online, we have a lot of high bids, higher than I've seen for these types of properties. I just want to say, if it's know your limit and stay within it is what my advice to folks. But we can move on. Okay, next slide. Okay, transfer of property. After the auction, we will report the sale to the district court. So we will prepare files for each property and a motion to the court. We will never take title to the property. It will always remain the previous owner. Once the sale is ratified, we will work to clear any liens, and we will schedule. We will call your title company or call you or notify you to schedule a settlement date. So it would also be helpful if you win a bid, we will contact you anyway, but it would be really helpful to know if you have a title company already, and to just send us an email, let us know you won this property, this is your title company, so we already have that on record. If you fail to settle on property through no fault of the city or one house, then we will retain your deposit and you will be prohibited from participating in our auctions for 1 year for each property that you fail to settle on. This is for if in the event that we can't clear liens, there's a bankruptcy or something or some unforeseen issue that is not your fault, then we'll terminate the contract at no penalty to you and return your deposit. But if it's something like, I know I can't get a lender, or I can't get the use that I want, or I couldn't get the zoning that I wanted for this property, then that's not a sufficient reason for failing to settle on the property. Next slide. Okay. Expectation of the buyer after receivership auction. I think we went over that already about communication and and pulling permits and obtaining a UNO within 1 year. Next slide. And the time frame for rehab. This is, I guess this is in an ideal situation. From appointment to auction, it's about 90 days. From sale to ratification, we say 45 to 60 days of ratification of the report of sale. Once the property is ratified, then there's 30 days to settle after ratification, and then 180 days to obtain a UNO. So that's the ideal time frame. Again, if there are issues with development, construction issues, things like that, we're not, we'll be open to discussing, any kind of extension if there's anything that arises from your development. Next slide. Other outcomes of receivership. So, we kind of talk about receivership and transferring this property to a bidder and getting that UNO, but other things that could happen indirectly from this process is that oftentimes we'll have a bidder who would want to participate in an auction, and because you can't participate in an auction, you can't be a qualified bidder if you have open VBNs or your properties that are not in compliance, then they will work toward getting those UNOs first or getting compliance first in order to qualify with us. So in some indirect way, we're incentivizing or, incentivizing other bidders to get their stuff together in order to participate in our auctions. In some other cases, the owners will also consent to receivership, and in some cases, there will be the city will allow a stay on that receivership to allow them to obtain a UNO. So it is there, and Katie can talk about how they use receivership in the city as as a hammer, and to make sure to compel owners to abate the nuisance themselves. So
right. Yeah, I can piggyback on that a little bit.
Sure.
Yeah. So it's just because the city files a receivership action does not mean that it's going to get to auction. Like I can't stress that enough. A lot of times with really, really poor properties in poor condition in more distressed neighborhoods, they are more likely to get to the vacant building receiver. But just because we file a receivership action, by no means does it mean the receiver will be appointed. But remember, the reason why the city is filing the receivership action is to get rid of the vacant building notice. And the use and occupancy is the end line. Whether the use and occupancy comes from the owner, comes from a mortgage lender, or comes from you, the buyer, after receivership auction, that's the end goal.
Mm-hmm. And the third outcome here, creation of recognized comparative sale values. We've seen this in areas where, especially in areas where we've done cluster auctions, where we would do, auction contiguous properties. They're typically in areas where there's no market there. So in essence, we're establishing something there, a price point in those areas. And because this is when the property settles, it is just a regular transaction. It doesn't show that it's passed through us. Becomes a comparable for sales in that neighborhood. So and then we could create or establish a market in some of these areas. Now, is this the last slide, Katie? Maybe there's another one. Oh, here. Unanticipated issues. Katie, this might be you.
Yeah, I think this is me. I think this is back to me. Mm-hmm. So remember how we had that great timeline? It would be fantastic if all properties that we filed receivership on filed that timeline or followed that timeline. Like I said, we have a large number of properties still held in title by dead people. And what that requires is a judicial probate. So that can take 4 to 5 months before we even get into court to file the receivership in order to get a personal representative appointed, in order to get somebody that we can actually serve. Auction sale prices will quite regularly be way less than government liens on the property. So Pia kind of alluded to this before, like once the sale ratifies, once you get your title company, the lien sheet is pulled, the city and a variety of agencies have to sign off to sever the liens from the property so that we can transfer a clear title. So sometimes, depending on the amount of the liens, the number of city agencies that are involved that have placed liens on the property, this could add time between the ratification of sale and your ability to go to settlement because we are working on that lien sheet. All things that could come up that could add time to the process. Successful bidder becomes another receivership candidate due to failure to rehabilitate. Don't let this happen to you, right? So you bought this property at receivership auction. If you fail to rehabilitate in a timely manner, we will not hesitate to file a receivership action against you. Remember, it's not the who, it's the what. We want a use and occupancy. That's the whole reason why we file the receivership action. And I think, as we've said a number of times, both P and I throughout the presentation, every property is unique. Everyone takes a different path to a use and occupancy. I think one of the best pieces of advice we can give you is you buy this property and all of a sudden all kinds of crazy things maybe have happened. You're not going to be able to rehabilitate within a certain period of time. One thing you can count on, you are going to get a vacant building notice. And if you do not stay in contact with your local area inspector, you will get a citation. They are going to be looking at you for high grass and weeds. You sure as heck better be pulling your permits because someone could come out there and slap a stop work order on you. You have to stay in contact with not only one house if you're having difficulty getting this property renovated, but you also need to make sure you stay in contact with city code enforcement and make sure that you do pull your permits.
I want to add one more thing too about the UNO. So if you purchase a property and you that is your property once it's transferred, so you can do whatever you want with it. However, if you decide to sell the property before you obtain a UNO, the responsibility of obtaining that UNO still falls on that receiver, on the original purchaser. It would be still on you. So even if you've sold it to somebody else, until that property receives a UNO, you cannot participate in receivership auctions until you've completed that property has a UNO. So it's tied to your bidder qualification. So if you can transfer it, it's your property, you can do what you want, but you have to be sure that the property that your buyer will obtain that UNO, because that still counts against your bidder qualifications and how many properties you can bid on for our auctions.
Okay, I think the next one. So this is kind of our summary, right? It's our top 10 on receiverships. It's not a government taking, it's a nuisance abatement tool. I think I've said that at least 20 times tonight. For the most part, when we're talking about court action, it can quickly address and remedy nuisance properties. Supports neighborhood, there's community involvement and strength. We do engage in community, particularly where we have blighted properties. Control of the property quickly moves to a third-party developer. By the city not having to take title, it moves it faster to someone who can abate that vacant building notice. There's, like I said, some versatility, looking for if there's common owned properties targeting specific blocks. We're looking at, this saves the city money ultimately, right? There are blocks that we need to demolish and there are blocks that should be renovated. So, putting dollars where we need to put dollars. Ultimately, bringing a property back online with the use and occupancy helps everyone in the city because now all of a sudden this is a productive property. We're able to collect taxes again and establish a market, right? And it creates that public-private sector cooperation. We can use this collaboratively with municipal acquisitions. Say DHC owns, 123 Main Street and we receiver 125 Main Street, then both of those properties ultimately can get use and occupancies. And like I said, it's the number 10, assist transferring property owned by dead people. So I can't, it's always a bonus when we can do that. Websites, codemap, definitely check codemap out. You can go to dhc.baltimorecity.gov right on the front page. It talks about maps and links, go right there. And we have One House's website here as well. So I think this is probably the last screen. So we'll leave this up for a minute and then we have like our closing screen. I'll leave this up for a couple more minutes and then I think the last screen might just have our names on it. Okay, so Kelly, how would you like us to handle questions?
Unmute myself. Hello. So I've just written down all the questions and I've tried to kind of combine a few that I think are very similar in nature. So if you'd just like to, whoever would prefer to answer, some are easier than others.
All right, I think we could probably, and I think we could tag team it.
Yeah.
Okay, so first and foremost, can you get a download of the slides? I do believe the slides will be available and we are recording the website or recording this presentation. So the presentation, if nothing else, will be available on our YouTube page, which is in the chat. So the first question is from Jan Evelyn, and she asks, what % of vacants are owned by deceased owners, out-of-state speculators, or other types of owners?
I don't necessarily have that off of the top of my head, but you'd be surprised the number of properties that are owned by deceased owners. I would say right now we have about 50 estates that are open and active. And every time we look at a new cluster, we generally get one more estate where the property is owned by deceased property owners. As far as out-of-state owners, we have a lot of defunct LLCs that are essentially Maryland corporations. And those are difficult sometimes to track down. Normally we could serve State Department assessments and taxation. But I think if you did like a little desk drive through codemap and you clicked on a property and you'd see, 123 LLC and they purchased the property in 2007, that's a defunct corporation because they purchased the property during the bubble. Sometimes when you see a vacant building and it's owned by someone and the property transferred, we kind of made a determination that when we see transfers older than generally 1980, more than likely there's a deceased property owner there if it's still titled by someone when the last time the property was transferred was prior to 1980. So those are just some of the barometers that we use to when we're looking at a property and looking at a block, we'll like, okay, this one's going to take a little bit longer, more than likely the property owner is deceased. We do a quick run on for corporations to see if they are forfeited with State Department assessments taxation. So while I do not have specific numbers, it's a common occurrence.
Yeah. I'm going to ask a series of questions about liens, but I'll ask the three together and then you can just answer them as one kind of fell swoop. But basically, is the process of lien abatement done before going to OHAT or after? And do the liens, once removed from the property, do they attach to the owner personally or the LLC that owned the property? And then finally, is the city doing anything to expedite the lien process? The developer is currently going through that process with receivership and has said that it's been a frustrating process.
First, the liens are not severed from the property. They remain on the property until right before settlement. Because if something happens and the property doesn't settle, then those liens are just hanging out there. So the taxes continue to accrue, interest continues to accrue, penalties continue to accrue up until that moment of settlement when they are severed. When they're severed at the time of settlement, they don't go away. They become the personal debt of either that defunct LLC or that prior property owner. So what happens is a bill is then generated. So all receivership does is take it off so that the property can transfer free and clear. We are aware of the issues with liens. I don't think it's not an uncommon issue it's not just receivership. I believe there is an issue with private properties going to settlement. and making sure that they get your lien sheets and people getting properties recorded on time. It is something that we are working on. We've taken it up to basically highest levels, Director of Finance and our Housing Commissioner, to try to figure out what we can do. We've instituted actually an electronic process. So if you think about it, right, the city's function is to collect tax. And what receivership does is it's removing tax from the one asset it has a lien on. But of course, we're going to do it because no one's ever going to pay this. Like, the property can't move without the lien on it. So we start that removal process, but in order to do that and stay compliant with the statute, there are a number of people that have to sign off on that removal and rebilling. And we have instituted a new process. So I'm hopeful that going forward, it will be faster.
Right. I also want to know about, removing liens before receivership. We don't know how much to request city remove until we have the sales price. So this is where, we have to do the math and do the research to figure out, what are the outstanding liens out there? Is there, a tax sale redemption we have to pay off, and things like that. And once we run the numbers and calculate if the property is still underwater, then we could take that, whatever amount that is, and request for the lien removal and rebilling. So everything has to, so we don't know what to remove until we know what our proceeds are going to be.
Great, thanks, Pia. The next question is, do you have thoughts about the auction and market prices being driven up to the point where rehab is not possible? Recently seen properties being bid up, but the owner might not actually have the money to rehabilitate.
This is interesting, right? I think P and I could probably do this a little bit together. And I think it's, we've seen in the in-person auctions, like there's a frenzy sometimes and people bid up and then they have bidder's remorse. And I think that we've seen that, and she's talked about this, how this has happened with the online auction as well. One of the difficulties is that the Constitution protects property ownership, and the law and the statute say that it needs to be sold to the highest bidder. We never want to set anyone up for failure. And the idea is, and I think Pia said this a number of times, know your number. And this is not unique. This is from the beginning of receivership. People have paid too much money for properties, have not had the ability to renovate them, and we end up re-receivering them. I still think it's a small number in comparison to the ones that actually sell and do get renovated. But the statute and the rule says it must be sold to the highest bidder.
Right. So, that's something that I think about a lot too, because seeing the online platform, there is always a frenzy. I think even in the in-person ones as well, although there's just a different dynamic when you're online and you can just easily click a button on the app. So again, what Katie's saying, there's only, because we have to, for constitutional reasons, right? We have to make sure that the property that is being forcibly transferred from that owner by the government we want to make sure that not only do they have the due process, but we're also we're providing just compensation. That's in the Constitution. So for us to put limits on how much they would pay, for us to put caps and things like that, we would run that risk of not giving that fair market price to that owner who is losing that property. It just so happens, right now we have because the court was closed, so we didn't have a lot of properties out there. So there was this, this demand was there, but the supply wasn't there. So it drove up these prices. So, that is a hard thing for us to weigh, because knowing development and knowing how numbers, we do scratch our heads too, like, how are they going to make that work? The best thing we can do is we've got to let that happen. And if that sale falls through, they can't fail to settle, then we retain that deposit, because this is essentially, there's no contingency, there's no financing contingency in our contract. Or so if they fail to settle because they can't make the numbers work, we retain that deposit and we re-auction the property. We just make it available. I also want to address too, I think there was a question directed to me, but I think everyone should also be aware that if there was a question about the runner from when we used to have an in-person auction. So when we had in-person auction, it was really, you've been to that, it goes by quickly. So it actually, when that person disappeared, that property had to get prepared for the next auction 2 months later, because we didn't know who was the second bidder or even how much it was. There was no, it happens quickly. That doesn't get recorded. Now that we have this online platform, we actually know exactly who the second bidder is, who the third bidder, fourth. So that actually has happened where the first bidder failed to appear. So we offer it to the second didn't, and then the second bidder has the opportunity to get that property if the first person fails. So that's another kind of advantage that we have having it online, because we actually have a timestamps of who did, who got the second, third, and fourth bids. And was there another part of that question? I wasn't sure.
No, I think you're good.
Okay, good.
Yes. As far as, I think you've kind of answered this question, so I'll mention it, that it was asked, and if you want to say anything else, but someone had asked, a couple people actually had asked about penalties for those that don't rehab, and are they prohibited from applying for future auctions if they have unfinished work? I do think you answered that to some extent, but if you want to just quickly recap that part.
The failed to rehab, there's failed to settle, and there's failed to appear, failed to rehab, and failed to settle, and then failed to rehab. The failed to rehab is pretty serious in our eyes. You pretty much are prohibited from bidding. It's never is, it's just not forever, but you pretty much won't be able to bid and be a bidder with us. That goes also if you purchase a receivership property and then you get receivered. The city files a receivership action against you. So you're pretty much never going to be a bidder with us if that happens.
Okay, the next question is, would you give any boost to a developer who has enhanced a neighborhood and possibly done like 10 houses in a neighborhood versus an auction or person bidding that has only done one property in the area?
Boost.
Like, would you give extra credit, I guess, for,
or I guess, or I think maybe they're asking
being in the
somebody to be
neighborhood.
a preferential bidder
Right.
kind of a thing.
Yes.
Like, I mean, I think Pia can probably answer this, but I can also say that, remember, we can't dictate outcome here, that it's a constitutional issue. And now it might make the person who's done 10 properties in the neighborhood and who definitely, you're going to sail through that pre-qualification possibly, right? Versus the person who's brand new, maybe only has the money, but doesn't have the ability, right? They might not get pre-qualified.
Right. And then also, we weigh your experience. If you have been really prolific at obtaining UNOs, and we know we can count on you to do that, then again, you will sail through the pre-qual. And if say, there's some issues, but you want to get pre-qualified for, you can get pre-qualified for more than 5 properties. We usually start off, even if you have billions of dollars, if you've never bid with us before, but you have the experience, we cap you at 5 properties. It's 90,000 per property, but we'll cap you at 5. If you've been established with us and you can demonstrate that you can do more than 5 at a time, then we can pre-qualify you for a lot more than 5. So that's I guess that's the advantage of someone who's been there, done that, who's kind of known to us and they can produce, is that you'll be able to bid for more, bid on more properties.
Great. why, the next question is, why does it take 45 days to get title when it usually takes 14 to 21 in other areas?
Well, it's because we have to pay for it, and we only have so many title companies that we can use as the city. And those title companies don't just work for the city. So we pay for our title privately. We pay for a 40-year title as to if we were going to do something like that. And we ask for a full title. Like our attorneys don't research title, they don't do title, we pay for it. So it's the sheer volume of the title requests that we do, and we only have 2 qualified companies. So it takes 45 to 60 days for us to turn that around. So remember, we've got 10 lawyers, we're filing 500 cases a year. It's a lot of title. And so it's budget constraints and who we're allowed to acquire title from.
Great. The next question is also about more of a data question. So obviously you probably won't have specifics off the top of your head, but if you have an estimate or know where this information will be found, they asked, of the 5,000 city receiverships, how many have been rehabbed, or what % have completed rehab, and how many were for homeownership versus rental?
I don't have the homeownership versus rental data. I at one time could tell you, because we look at use and occupancies and receiverships differently. So we look at properties that have been demolished, properties that have been renovated. We look at even from the time that we file, that we never get the order if they get a use and occupancy. We also have properties that sell privately. So I don't necessarily have that off the top of my head, but what I do know is of all the tools that we have in the toolbox, receivership is the most proficient at getting use and occupancy outcomes.
Okay, great. Is the city considering more receiverships in quote unquote weaker markets now that the overall market has been on an upswing?
No, I think the way that we make determinations on receiverships are we look at particular neighborhoods and we look at the but for, right? There's no reason why this property should be vacant, and we file a receivership action. We only strategically look at blocks when we know that there will be an interest for a whole block outcome. We know that there's at least one person or one developer who has the ability to purchase all of the properties and renovate each and every one of them. The one-offs, maybe in a more distressed area, if we have a vacant building next to a particular property owner and that property owner has reached out to code enforcement, reached out to our office and said, I'm interested in receivership at this particular property because it's my neighboring property. I want to renovate it for like my mother, my daughter, or my son. We'll ask that you pre-qualify with one house at a time, and then we will go ahead and file a receivership action. A lot of it is volume. So we have planned out properties where we are going to file receivership actions on. I think one of the difficulties right now is we're a year behind in filing. So we have plenty to file. I mean, we have plenty that are going to be coming down the pike. The problem is getting it into court, getting it through the court process. Like I said, we're literally 500 in the hole where we should be. We should have pumped out at least 500 more receiverships at this point than we did last year. So there's plenty of product, right? There's definitely plenty of product. And I think that what you'll see is hopefully in the next 6 months, we'll have more properties in the auction and we'll be able to continue to move forward.
Right. And I want to add to that too, that, when a property, if you go to our website, you'll see upcoming auctions, and there's also a link to our immediate sales portfolio. So those are properties that have failed at auction. So if nobody bids on a property, which means there's no market for that property, then we move that property to immediate sales, which is available to anybody, any pre-qualified bidder who would want to make an offer. And usually these properties are below $5,000. So, we had, I think, 50 or 60 of those properties on our available as a direct sale in early 2020 during the pandemic. Of all of those sold. So, that just kind of tells you, we were just lacking. There's such a shortage of vacant properties that even, we always consider those properties were the worst of the worst, but they sold. And I think we have maybe 2 on our website right now. So, but that's the kind of what we're dealing with as far as the demand.
Right.
So hopefully once court opens up a little bit more and we can file more, we'll have more properties this coming year.
And the last thing we want to do is speculate with OHAT's resources, right? So we do not just file receivership because there's a vacant building notice. We need to make sure that there is a buyer there at the end of the day. So in distressed markets, either a developer, a neighbor, someone has proven that they have the ability to renovate in that block. We know we have someone, at least one person who has an interest in that. So it's not our MO, so to speak, to just say, you know what, we're going to receiver all these properties because this is a really distressed block. We can't do that to OHAT because it costs them money to put the properties into auction. And if we don't have some kind of good faith backing that someone will buy them, then we lose our receiver, we lose a program.
Right. And once we're appointed, and also once we're appointed receiver, we are authorized by the court to sell the property, but we can't, we don't own the property. And the current owner has been divested of their authority to rehab that property or do anything with that property. So this property becomes in limbo. So it really needs to be, once it's receivered, we really need to transfer it. The whole point is to get it to somebody who will take ownership and get that UNO. By kind of, if we can't sell, if the property can't be sold, there's no end buyer for it. It just becomes a zombie property that, we can't do, nobody can do anything to. So it really is important to be able to transfer it to someone.
So just a quick reminder, we do have a hard stop at 6:45, so we've got about 2 or 3 more minutes. And so if your question didn't answer, do apologize. I'll take down all the questions. I have taken down all the questions from the chat, and hopefully we can get answers to everybody.
Hey, Kelly, can I ask a quick question?
Sure.
Yeah. Good evening. This is Howard Tubman, Neighborhood Development Officer for Central and West Baltimore. Katie and Pierre, I had a quick question in regards to the registration. It's $90,000. As everyone is aware, recently in West Baltimore, we had a vacant building go for $82,000, $40,000, $50,000. Is there any consideration for increasing the registration for OHAD since the auctions are going in the 50s, 60s, and 80s?
I'm sorry, what do you mean increasing their registration?
Well, it's $90,000 to register for OHAD, and you recently had a sale for $82,000.
Oh, I see.
So
this is, okay. So you mean the 90,000? You mean the amount of the financial capacity to show that?
Yes, exactly.
So we've kind of gone back and forth about having that number there because the market, changes. So that's kind of that's something we're looking into, because it's almost we don't want it to be an arbitrary number, but we also, again, for certain properties, it would be helpful to have a higher threshold, but that's usually typically reserved for like a property like a large, I think we've had a commercial a receiver, like the Sellers Mansion, for instance. So we've had a higher threshold for certain sort of properties like that. I think that's something we have to consider. I'm not sure that we have to look into that, because it's a matter of also like just making sure that we don't have a huge barrier to becoming a bidder. Keep in mind too, we only really have, I want to say, 300 pre-qualified bidders. at any given time. And when you're talking about thousands of vacant properties in the city, how can only 300 qualified OHAT bidders, be able to address that? So, we have to kind of balance that access and also not make it too onerous for other, for other folks to be able to be a bidder. Another thing too is that, it's kind of like we don't really know how much, like that property maybe 2 years ago may have only fetched 15,000, but I can't tell what that's going to be. That it's going to, someone's willing to bid 80 on that property today. So it's hard to judge, when do we can't keep moving the target either. So we have to have that threshold, and it has to be kind of uniform for everyone. Bidding on a property, some areas, some properties are only going to be $5,000 or 10K. Being able to show that you have 90 seems reasonable. But again, there's no way for me to tell what the market will pay for a certain property. So, we've definitely discussed, changing the threshold, but then the market might change in a year. So, maybe 90 won't be appropriate. Maybe 90,000 would be too burdensome. So that's hard to really, to assess that.
Thanks, Pia.
Mhm.
I'm just going to ask one final question, and it relates to the 1 year for rehab. Someone had asked if you're doing, it's two-part, if you're doing demo for new construction of a building, or if it's in a CHAP area where the approval process takes a while, what are you willing to extend the 1 year deadline for reasons like those?
Yes.
Yeah,
We have
yeah,
a couple properties like that now.
Yeah, I mean, we all understand that. The key is make sure you stay in make sure you make your intention clear to not only to OHAT, but to that area inspector and to the code enforcement attorney.
Mhm.
Great. Okay, well, I think we're going to end it since we're a little over time, but thank you very much for answering all these questions. And Eric, is there any final thing you'd like to say?
Just want to remind everyone that this video will be up on our YouTube channel within 48 hours. So you can go back and review it. And we have other webinar series that we've done over the course of the year that are also on our YouTube channel. So if you missed any of the other workshops or webinars, please feel free to go to our YouTube channel and review those. Want to thank again Pia and Katie for the presentation today. Very informative. And most of all, we want to thank everyone who participated in the webinar series tonight. We look forward to working in partnership with you. Thank you for your commitment to improving the quality of housing in Baltimore.
Can I plug our next auction for those?
Absolutely.
Who are interested? Our next auction is online, and it'll be on December 7th. If you want to be get pre-qualified, you have to submit your application to us by November 30th. If you have any questions about the application, or if there's a question here that didn't get answered, feel free to email me, call me, and I'll try to help you out and answer your questions. So thank you.
And final thank you, Kelly. Thank you again for facilitating the question and answer period. Howard Tubman, who's a neighborhood development officer for the west side of Baltimore, and Teresa Stevens, our leader. She's director of community outreach and marketing. Thank you, everyone, and have a great.
Thank you. Thank you, everybody.